Hi, everybody. I'm Emily. Welcome and thank you for joining us for the next installment of our webinar series. And today we're going to focus on Title IX and employee rights. So before we get started, there's just a couple of housekeeping things that we want to address. First, to the left of your presentation slides, you have the ability to type in and submit questions. So please feel free to ask questions throughout the program by using this feature, and we'll do our best to address those as they come in. And then also, everyone logged into today's program is going to receive an email that includes a link to the recording of the webinar, today's presentation, and a survey. So please fill out that survey if you'd like CLE or SHRM credit. So let's go ahead and get started. So like I said, my name is Emily Tulloch. I'll be presenting today with Jackie Wernz. Jackie and I are both members of the firm's higher education and K-12 practice groups. We both worked together for a time at the Chicago office of OCR, and we're both two of the authors of the firm's Title IX blog, which is title9insights.com, where we both exclusively blog on issues relevant to school administrators and leaders working in the Title IX realm. So for those of you who aren't familiar with Franczek, we're a boutique law firm located in Chicago that focuses on labor, employment, and education law. And this year we're currently celebrating our 25th anniversary. Our firm has one of the largest teams of K-12 education lawyers in Illinois. And we work with school districts, schools, and cooperatives of all sizes, ranging from hundreds to hundreds of thousands of students in all areas of the state. Franczek attorneys collectively have decades of experience representing public and private research institutions, community colleges, liberal arts and graduate schools, academic medical centers, and for-profit higher education institutions. And we work closely with in-house counsel on a wide range of higher education law issues, from day-to-day counseling to high-stakes litigation, internal investigations, and audits. So today we'd like to invite you to join us in some polling so that we can interact a little bit better with you during our webinar. And to join in on the polling, a poll is about to appear on your browser. And then once we kind of bring up the questions, you can make your selection and we'll share the results with you. So our first polling question is, my institution is, and you can answer A for public institution, B for private, and C for other, if you perhaps aren't at an educational institution. And this is just to get a feel for the types of institutions where you all are working kind of as we work through this presentation. So it looks like a lot of you are from public institutions. We have a little bit from private and a couple that are indicating other. So the great majority right now we're seeing is public institutions. And so we have another question coming up. And our next question that we'd like to know is what level your institution is. So A for K-12 institutions, you can indicate B for higher education, C for both, or D for neither. We'll give you a second to enter those options. And so we're seeing a lot of K-12 and higher ed responses, a couple neithers as well in there, but about half of you are from K-12. And finally, we'd kind of like to get a sense of what roles are being represented today throughout the different types of institutions. So if you are in a Title IX role, such as a Title IX coordinator or investigator, you can answer A. If you are in a human resources role, you can answer B. And we know many of you wear multiple hats. So if you're kind of juggling both the Title IX and human resources responsibilities, you can select C. And then finally, I'm sure we have some people who aren't covered by any of these traces, so please select D for none of the above. It looks like we have a pretty even spread. There's a lot of people who are indicating HR only or both responsibilities. Kind of like we said, we know a lot of you wear multiple hats, so seeing that a lot of you have indicated both isn't surprising here. So now that we kind of have a sense of who is here today, let's jump right into discussing the law. And we have one more quick polling question to kind of get us started. So our first polling question is going to be, when it comes to employee-on-employee sexual harassment or assault cases, the Title IX coordinator at my organization, A, wouldn't have a clue that's HR's problem, B, wouldn't be involved but would hear about it at some point, or C, would either handle or be involved directly in the investigation and or resolution of the complaint. So this is kind of the situations where you're having both an employee reporting the sexual harassment and an employee who's responding to the harassment complaint.
So Emily, and hi everyone, this is Jackie. I'm interested here that I'm seeing a lot of responses that the Title IX coordinator at the organization would either handle or be involved directly in the investigation and resolution of the complaint. So it looks like right now we have about 22 users who are saying they would either handle or be involved directly in the investigation of an employee-on-employee sexual harassment or assault case, and then about 5 users who said wouldn't be involved but would hear about it at some point. And I gave a similar presentation to this in October, I think, at a TICSA's West Coast conference, and that was both a mix of higher ed and K-12 administrators as well. And during that conference, I actually would say that a much larger number of people indicated that when it came to employee-on-employee sexual harassment or assault cases, that the Title IX coordinator at the organization wouldn't necessarily be involved with that. So it's very interesting to see the different polling responses that we've received here, and we'll try to be a little flexible in our discussion today so that we can address that issue.
So employee-on-employee conduct, it's important to remember, especially when we're working with students, that these types of conduct can also have ripple effects in the larger education community, which may mean that your institution's response can't be siloed kind of between those HR and Title IX roles. So, for example, think about if a male professor is making comments toward another professor on Twitter, but students can also view those comments. Is that then a should-have-known situation where the complaint of an employee-on-employee misconduct should have triggered some additional investigation into whether there was a wider effect on students in the community? Or thinking about in the K-12 realm, comments between one teacher and another in the classroom, depending on the environment, could have an impact on students. So obviously these circumstances are relatively rare, but it's important to kind of remember that those interactions can occur and what our responsibility is to respond.
And so it seems like, based on what we saw as the survey results today, that the vast majority of you are actually, you aren't siloing these issues in the way that we've often seen. And so what I'm hopeful of is that it isn't just a situation where your Title IX coordinator is on the HR side and you've got someone else who's handling student-on-student or employee-on-student complaints. What we like to see is communication across the board, even if in many cases, it's extremely likely that you're going to have multiple people with control over these issues and these types of complaints, but we want to see the lack of siloing between all of the different individuals who are playing a role.
Yeah, so like Jackie said, at the very least, we want to see some communication between human resources and Title IX, especially about the trends they're seeing and any matters that might be implicating students, even kind of on that peripheral level. So let's kind of think about another polling question, and it's slightly different. So when it comes to employee-on-student sexual harassment or assault cases, the Title IX coordinator at my organization, A, wouldn't have a clue that's HR's problem, B, wouldn't be involved but would hear about it at some point, or C, would either handle or be involved directly in the investigation and or resolution of the complaint.
So this is really the flip side of the question that we asked earlier, which is we asked first about employee-on-employee sexual harassment or assault cases. Now we're asking about employee-on-student sexual harassment or assault cases. And now I'm seeing what I expected to see from some responses, which is that some organizations are saying the Title IX coordinator wouldn't have a clue about these things, that's someone else's problem that has been separated out.
So we tend to see that type of siloing between Title IX departments and HR departments a lot more in the K through 12 setting, at least from our experience. And I can't stress enough, again, how important it is that your Title IX coordinator is involved in some way with all complaints involving students, even if the responding party is an employee. So OCR has longstanding guidance out that requires that a recipient that designates multiple coordinators should designate one lead Title IX coordinator who has the ultimate oversight responsibility. So in other words, it's expected that you have one Title IX coordinator that has oversight over all matters that potentially implicate Title IX. And that certainly includes any matters where a student says they're a victim of sexual misconduct. And if you have an individual in human resources who's handling complaints of sexual misconduct by employees against students, you should also consider whether that person is going to be designated as a Title IX coordinator or deputy as well. And at the very least, that person needs to have sufficient training and understanding of Title IX to make sure that they're in compliance with Title IX as well.
And just a technical issue real quick on the webinar, it appears that when you're done with the polling, you need to click the X box in order to go back to seeing the slides. And then when we put forth another poll, it will pop up again over the slides.
So that's a great segue kind of into our next topic, which is sexual harassment and misconduct policies and procedures. So what we've been talking about up to this point is practice. So that's who's doing what and how and when. But the practice also must be clearly communicated to your community via your written policies and procedures. So you have another poll coming up. And one way to think about your policies and procedures kind of is, does your institution process employee on student sexual harassment complaints under the same process as student on student sexual harassment complaints? So you can have options to choose here between yes, no, it depends, or I don't know. So we're seeing a lot of results come in. It's pretty even between no, it depends, and I don't know. So we're seeing a lot of you kind of say, for the most part, your institution is not necessarily processing employee on student complaints the same way as student on student complaints, or it depends basically depending on the particular situation or facts of a certain case.
Yeah, so it actually looks like now that the results are kind of flowing in here that I would say the vast majority of the respondents to this survey are saying, no, my institution does not process employee on student sexual harassment complaints under the same process as student on student sexual harassment complaints. And I actually think that's, again, a very common, the most common response.
So what we often see, kind of as Jackie stated, when we conduct audits for K-12 or higher education institutions, is that what's written down on paper also doesn't really necessarily match up with what's done in practice. So the risk, if you're using more than one policy or practice, is that you're going to have confusion over, which policy will be used, who's investigating it. Is it someone in the Title IX department? Is it someone in human resources? Who's the supervisor? Is it the Title IX coordinator? Is it the head of HR? And who is the ultimate decision maker? So this can be really confusing, and especially when policies say to use a particular process and then it isn't used. And we actually have a blog post that we recently posted on Title9Insights.com that kind of goes into more depth about the risks of this really common issue if you're looking to take a little bit more of a deep dive. And even if you aren't confused as school personnel, the reporting and responding party may be confused. So, think about handling the terrifying ordeal of being a victim of or accused of sexual assault, and consider how clear it will be for that person which policy is going to be used. All of this becomes a lot more complicated even when you're dealing with cross-category respondents. So those are particularly in higher education when you see faculty members who are also acting as students and taking classes, or students that are teaching classes, or students that are otherwise employees at the institution in a number of different ways. And so sometimes the alleged misconduct can cross between employee and student roles. And when you have a different policy or procedure that applies in each situation, it can be very confusing, both on your end and on the student or responding end. So another risk when you're using multiple policies and procedures is the duplication of resources. So are you processing complaints with an employee as the responding party in a different department? How are you tracking those complaints? And is it seamless with your student-on-student complaints? And another thing to consider is training. Who's ensuring that the training that your employees, and that includes those student employees, and your students, comport with the expectations of Title IX?
Okay, so again, this is Jackie, and I'm going to talk a little bit more about some of these policy considerations at this point. So another important risk you can see when you're dealing with a range of enforcement policies and procedures is a lack of notice. And this concern doesn't just impact the student who, as Emily discussed before, may not know what process or procedure is being used to address their situation. There are also, I believe, serious concerns with both prevention and due process that come up with this issue of lack of notice. So on the prevention side, the concern is that particularly when you're dealing with someone who's a cross-constituent employee, so they have roles both as an employee as a student. Maybe you've got someone if you're a K-12 institution who has a cross-constituency role as a parent and a volunteer, for instance, they may not be aware of the limitations that are placed on them. And so that can really hinder your efforts to prevent harmful behavior. So when I was at OCR, to give one example, I handled a complaint involving a graduate teaching assistant at a college or university who had consensual sexual relations with freshman students. And when these incidents were reported, he was unclear as to whether his conduct could lead to consequences as an employee because of the way the policies and the collective bargaining agreement were written. So this wasn't just a concern to me as an investigator because of due process issues. I mean, that was an important point that was raised, was he said, how can I be held responsible when you haven't clearly told me that I'm limited in the same way that employees are limited when it comes to consensual relationships? But it was also a concern to me because I genuinely felt more communication might have led this individual to consider his recreational activities. Had he known, his PhD might have been in jeopardy. But the policies were very unclear on this point. So again, another reason why having different policies or practices that you use, depending on whether or not the responding party is an employee or a student, can lead to some of these notice concerns. Okay, now our next issue that I want to touch upon, and I'm sorry, our slides are moving a little bit slowly today, so they're having a hard time keeping up with us. I guess we're fast talkers, but the next point is deals with consequences that the institution wants to impose. And so that actually was an issue that came up in that same OCR matter that I just mentioned. In that case, the teaching assistant was disciplined as a student by being expelled from school and as an employee by losing his teaching assistantship. But when we dug in, we realized that the school hadn't given the teaching assistant the process that was outlined in the HR policies applicable to teaching assistants. His situation was addressed only under the Student Code of Conduct process. So that obviously can be an issue, and a good rule of thumb is if you're dealing with distinct policies, look at the consequence that you are wanting to impose and ensure that you're following the correct policy for that specific consequence. All right. Our next point, another question that often comes up when you're dealing with these types of distinct policies is an issue of equity. So why are we treating employee respondents and student respondents differently? What is the justification for requiring a student who is complaining of sexual misconduct by an employee to go through a different process than a student who is complaining of sexual misconduct by a student? And on the flip side of that, what is the justification for requiring a student who is responding to a complaint of sexual misconduct to go through a different process than a student who is complaining, than an employee who has been complained about? So I think you can probably tell, based on our slides and what we just discussed, that our advice and our belief is that if you have a uniform process for addressing student complaints, regardless of the responding party status, that can really be a better option for your institution. And I think the reasons we've made pretty clear so far in this discussion, but I want to talk through what I see some of these benefits explicitly as being. So first of all, when you have a truly uniform grievance procedure for sex-based claims, you are removing the risk of confusion that we have talked about. And in an ideal world, I'd love to see one person with ultimate oversight over all sex claims. But although I think there are real benefits to using the same process to address other types of civil rights complaints, so we could talk about that, could do another whole other webinar on the benefits of using the same process to address race complaints or disability-based complaints, and there are also some downfalls to that as well. But what we do know is that according to OCR, and I think in practice, there are very serious risks that when you try to combine more than one civil right under the same coordinator, it can be very overwhelming, particularly for large institutions. And so what OCR has long pointed out is that we need to make sure that coordinators have sufficient time and resources and energy to adequately oversee the process. And if they're also handling disability complaints and race complaints and other complaints, that can get difficult. But one thing I think you should consider is how can the strategic use of deputy coordinators relieve a lot of that burden and make it possible to have one person who is sort of thinking about your climate on a much broader level than just Title IX sex-based complaints, but is thinking about issues of equity and things like that at a much greater scale. Because having a person who's very knowledgeable and informed at that high level, who's thinking about the potential impact of all of the civil rights, I think is very important, but it requires some thinking and some strategy on how you're going to allow that person to manage the day-to-day of more than just sex-based complaints. At a minimum, it is extremely important to, as Emily mentioned earlier, to cross-communicate. I had an OCR on-site at a private college where the Title IX coordinator and the HR director were responsible for overseeing complaints against members of their own constituency, and they never talked. They had no concept of what the other hand was doing, and in the end, it was a serious issue for them because they had some significant climate concerns that they missed because they were so siloed. and I've seen this even just recently in working with some of our K-12 clients in doing audits and trainings, that a number of our K-12 clients are also very siloed in that same way. So remember that if you are splitting responsibilities between Title IX and HR, it needs to be very clear to potential complainants and respondents which policy will be used.
Okay, so let's switch gears a little bit and talk about privacy issues when we're dealing with employee respondents. So we have a number of issues that we've kind of pulled together under this umbrella of privacy. And the first one that we're going to talk about is academic freedom and First Amendment concerns. So according to OCR, sexual harassment does not create a hostile environment under Title IX unless the harassing conduct is sufficiently serious to deny or limit the student's ability to participate in or benefit from the school's program. So OCR has said that Title IX is intended to protect students from sex discrimination, not to regulate the content of speech. And the offensiveness of a particular expression, as perceived by students on its own, is not a sufficient basis to establish a sexually hostile environment under Title IX. So OCR has kind of said that schools have to formulate, interpret, and apply their rules to make sure that they're protecting academic freedom and free speech rights. So the question then is, how and when do you do that? We suggest that you take a cue from OCR in how it addresses these questions in its investigations. So under relatively recent additions to OCR's case processing manual, OCR considers this academic freedom First Amendment question kind of as a threshold issue and to be considered throughout the processing of the complaint. So you kind of have to consider whether a finding, if made, would infringe on First Amendment or academic freedom rights both at the beginning and throughout if certain concerns arise. So using the same approach, consider it, as the threshold question and then throughout your investigation. There is a recent case from the Fifth Circuit Court of Appeals, Buchanan v. Alexander, which is a really great reminder that the First Amendment is not a bulletproof shield. So even in the realm of higher education where tenure protections are really at their strongest. And in that case, an education professor regularly used profanity in her classroom, talked about her sex life, talked about the sex life of her students. She ended up being fired despite being a well-respected and tenured professor, and the firing was upheld by the Fifth Circuit Court of Appeals, which found that she was not speaking on a matter of public concern because her speech was not sufficiently related to the curriculum of the class that she was teaching. So similar standards could really be applied in the context of academic freedom cases, which usually arise in private higher education institutions where there's no First Amendment right, but the right to academic freedom is contractually provided. In the K-12 realm, First Amendment and academic freedom protections are much lower. So although you do still need to engage in the analysis to avoid having your decision be challenged, but considering kind of your location is also important.
So another issue that we put under this privacy bubble is with respect to community communications about complaints involving an employee. So what we're really talking about here is both prior to and after your investigation findings, how are you communicating with your community about what has happened? And when we deal with student complaints, it's a much easier question, right? Because we're going to have FERPA come into play and our state laws that also in the K-12 context limit sharing information about students. But it's important to remember that when a faculty member is the respondent, that FERPA really doesn't play any role in protecting their records. And Title IX as a federal law still requires sharing of the outcome of the complaint regardless of state-based employment privacy laws. So a complainant should be notified the same way that they would be in a student-on-student complaint about sanctions and responsive actions, but you also need to keep in mind that you may be required to, and you may want to share information with your community about complaints against an employee on a greater scale than you would if it was a student-on-student complaint.
And lastly, don't forget that if there is an underage victim of alleged sexual misconduct, you almost certainly have a responsibility to report that conduct to Child Protective Services. And just to note, we've recently seen Children and Family Services in Illinois specifically looking into incidents of alleged employee-on-student misconduct in school as purported evidence of, institutional concerns, broad-based institutional concerns. So if anyone's kind of interested in learning more about that, we can, chat about that later.
So very quickly on the issue of retaliation, what I typically see in advising clients on where an employee has been alleged to have violated Title IX or Title VII, when they've been found to have engaged in sexual misconduct, it's a lot easier to figure out what to do with the relationship afterward. But what's really difficult is what happens when an employee is found not responsible for sexual harassment, but they have some kind of ongoing responsibilities to the student, such as teaching and advising. And employees will often say in this context that they fear that the student will complain again. And so then they limit interactions with the student in an effort to protect themselves. And obviously the concern with this is that you could have a complaint of retaliation. And the very short takeaway on this point is that we need our employees to understand through very good training and counseling with them during these complaints that rebounding from complaints made in good faith comes with the territory of working in schools, and that it's essential that they repair that relationship. We did have one question to ask about would we touch on the intersection of Title IX and Title VII. I'll tell you, when we do this as a 2-hour training, we spend a lot of time talking about Title IX and Title VII. I'll say this to you, that we talked about siloing earlier, and I think the most important thing is that we not get into the mentality that this is a Title VII issue or this is a Title IX issue. In many jurisdictions, an individual could actually file a lawsuit in federal court alleging Title IX violations based on employee sexual harassment. That's not true in the Seventh Circuit. You do have to go through Title VII here, but that's not the case across the country. And even in the Seventh Circuit, I think we can sometimes get lost when we try to make these distinctions between this is an employee-on-employee complaint versus this is a complaint involving a student victim, whether it's cross-communicating or making sure that you're keeping an eye on data so that you know what the impact is on your greater climate. I think it's very important that we not make these distinctions between Title IX and Title VII that can sometimes get us in trouble. Thank you all so much for joining us. We really appreciate it. I know we've gone about 3 minutes over, so we appreciate you hanging around. We hope that you found our program helpful, and our next webinar in our series will be on January 21st, where we will be discussing student medical issues, so we hope you will join us for that. You will receive an email today with the program's recording. Please feel free to share that, and you'll also receive a link to register for our upcoming webinar and the evaluation survey. Again, please make sure to fill out the survey if you'd like CLE or SHRM credit. Your feedback is really invaluable as we plan future webinars, so if you have any topics you'd like us to cover, please let us know. Thank you and have a great afternoon.